I guess I'll represent myself.
Okay. You understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
You know, I caught...
Buckle up, guys. Today, we're diving into 5 sovereign citizens, 5 courtrooms, and 5 disasters in progress. Each one brings their own brand of defiance, from self-proclaimed nationals to parents sabotaging custody hearings. But first, irony meets reality with a sponsor, Aura, the tool built to protect people from data leaks. While millions lose privacy online, these defendants fight against laws they barely understand. The stage is set. Arrogance meets accountability. After the sponsor break, we begin in Kansas, where one man's delusion meets legal consequence.
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
On the second.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here.
Oh, okay.
What your bond is, and give you a court date, an evidentiary hearing date, which is July 26th.
In Kansas, Mr. Walker reappears, a returning sovereign who once rejected every form of legal counsel. Last time, he pled guilty to a drug felony, alone and proud. Now he's facing probation violations for never even reporting. The judge, calm and procedural, offers him representation once again, but he refuses, repeating that he won't sign anything. It's the classic contradiction. He denies authority, yet demands leniency. Each word he utters reinforces the tragedy of stubborn ignorance masquerading as independence. The courtroom, however, deals only in reality.
At 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it. File.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll be around and be available for you, okay?
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
Okay.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of
I don't
Michigan.
have to be registered. You don't have license to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this, and I'm
Okay.
challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks?
Walker's fate sealed, the narrative shifts to Detroit, where a man named Albert Hicks awaits. The commentary sharpens. Tone turns heavier. Hicks isn't just another self-styled sovereign. He's a repeat performer, famous for turning hearings into hostile debates. The narrator sets him up as the embodiment of arrogance in a suit, someone who believes shouting jurisdiction makes laws disappear. But this courtroom won't be his stage for long. What's about to unfold is a battle of composure versus chaos, reason versus rebellion.
You want a trial date or you want the
I'm
offer that's in the
challenging
back?
jurisdiction. I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to
Write it
put
up.
it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have
Okay.
delegated authority to do that.
Okay. All right, well,
I'm
Trial
challenging
date?
jurisdiction.
trial date, I'm denying, what is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so,
Honor your oath of office, please. Honor your oath of office, okay?
are we going to sit here and debate those
It's not a
positions?
debate. It's my constitutional right. It's my constitutional right.
You think so?
I
Okay,
know
so,
so. Are you violating my constitutional rights on how you deem them to be?
no, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a
Please.
transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you gonna do today, Mr. Hicks?
Challenge jurisdiction
And how are you challenging that?
because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case,
Okay.
and I deny that motion.
Why you
If
denying
that-
the motion? Because you don't have.
Even if that is, so Mr. Hicks, you're a grown man. Let's have a few seconds, wait a minute. Let's have a few second conversation, okay? Now,
Okay.
let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying, no, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What
Beautiful.
basis are you denying the motion?
Albert Hicks enters the Detroit courtroom brimming with misplaced confidence. He declares himself his own attorney, then mocks the judge's authority. He refuses motions, interrupts the bench, and demands proof of jurisdiction. The judge listens, then calmly fires back, reminding him that Michigan law, not imagination, governs the room. Each denial tightens the walls around Hicks' delusion. The tension builds as logic dismantles fantasy. What he calls freedom is just confusion in disguise, and what he calls courage is nothing more than defiance without direction.
To dismiss.
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10-3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public
information.
information.
You're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a license.
I thought about that. Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to talk? You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
The end comes quietly. When officers fail to appear, the judge dismisses the case, not for Hicks' brilliance, but for due process. Hicks smirks, demanding payment for defending himself. The judge doesn't entertain it. Instead, the narrator cuts in, explaining why justice must remain cautious, even if it means a few guilty go free. The system's restraint isn't weakness. It's the price of fairness. Hicks leaves believing he's won, but in truth, the court simply walked away from his chaos. Sometimes silence delivers the harshest verdict.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on, and I'm going to put you out, or at least mute yourself. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Chiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we gonna do? The officers were supposed to be here today. I'm only dealing with SP 1442547, counts 1, 2, and 3, SP 144-27651, and SP 5008721. I'm only dealing with those matters. And the officers are not here. So we're gonna make this easy. And now, what I don't appreciate is, you know, I thought about that comment that you made that last time. You know, basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm going to dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
Now we shift from arrogance to consequence. Hicks returns, this time accused of domestic violence. His long-term partner testifies softly, naming him as the father of her children. Hicks sits motionless, his usual defiance fading. The court listens as years of control are exposed under oath. For once, the man who challenged authority has no script to hide behind. The room feels colder, heavier. This isn't about law, it's about morality. The camera lingers on his face, and the silence says everything arrogance never could.
Attention to the look on his face as she testifies against him at his probable cause hearing.
Is that Elder Hicks? Yes. Okay, and how do you know that person? He was my partner, and he is the father of my children. Okay. How long were you guys partners for? 14 years.
So, for the record, I've made the special visitation under duress pertaining to the matters of Jonathan Troy, Faifu Leaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status, and so I ask you, ma'am, what is your name? What is your nationality, and what is your status?
I'm Judge Grant. I am a citizen, and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
The focus turns to Washington, where a new sovereign steps into frame, Jonathan Schuster, a self-declared American national. He believes laws don't apply to him, that jurisdiction is a choice. His confidence mirrors those before him, but this time the delusion is polished, almost rehearsed. He speaks in riddles about status, flesh and blood, while the judge remains composed. The scene resets our expectations. Madness doesn't always shout. Sometimes it speaks with calm conviction that only deepens the absurdity.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status, And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case
That would
with
be
prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I
object.
challenge the jurisdiction, and jurisdiction must be
It's
proven.
not going to happen today. Today,
Jurisdiction
you're
must be
here
proven.
to hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also.
In Judge Grant's courtroom, Schuster performs a monologue built entirely from pseudo-legal fantasy. He questions the judge's nationality, claims to be sovereign by blood, and insists that citizens can't sit the bench. Every phrase collapses under the weight of real law. The judge, patient yet firm, lists his violations one by one: license suspension, expired registration, multiple offenses. The courtroom becomes a mirror, reflecting how belief without knowledge can make a person blind. Sovereignty, he learns, isn't about freedom. It's about facing reality.
It would just add to that. And I
You
don't
can do
think that
but
you
right
need,
now, I'm
you
gonna
need
have
to go that
stop
route.
talking while I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the
Unless you
law.
want to enter a plea of guilty, today there'll be a plea of not guilty. I understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
We pause for perspective. A retired Michigan family court judge appears on screen, recounting how sovereign citizens have turned legal fantasy into real-life harassment, filing fake liens, threatening families, and flooding courts with nonsense. It's a chilling look at how ideology spreads when unchecked. The narrator ties it back to the bigger picture. These are not rebels. They're victims of misinformation. What began as defiance has grown into a movement built on paranoia, and the legal system is left to clean up the fallout.
Right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating.
Again,
laws.
I was not driving. Again, I have rights.
You were behind.
And my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am
you.
sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concern about community safety and risk of reoffending, given his temperament in the court today.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would.
Back in Washington, Schuster refuses to stop. He objects to everything: jurisdiction, charges, even the judge's right to speak. Calmly, she enters a not guilty plea, sets bail at $2,000, and appoints counsel despite his protests. The prosecutor notes his temperament as a risk factor, a quiet acknowledgement that delusion can be dangerous. The narrator closes with clarity. Belief without law is chaos, and chaos always collapses under truth. Justice doesn't shout, it endures. Like the video, subscribe, and we'll see you in the next one.